stand. Please have a seat, everybody. Mr. Strickland, I have approached your submissions over the past 12 years with the utmost suspicion. But perhaps things will be different today. Do you move?
I do so. Your Honour, I begin with an acknowledgement of country and pay my sincere respects to the Gadigal of the Eora Nation, traditional custodians on the land on which we meet, and their elders past and present. Those respects extend to all First Nations people. Your Honour, I propose a very efficient swearing-out speech to be divided into 3 tranches. If there are any applicants for bail, in accordance with the custom of Your Honour's court, those applications will be heard and refused in the first tranche by 9:45 a.m. The twofold purpose of this speech is A, to recognise the significant contribution of Your Honour to the court over the last 11 years, and B, consistent with the principle of finality, and despite Your Honour's evident popularity, to ensure this is the only swearing-out speech of Your Honour. Both Justice Button and I are contemporaries of a number of justices of this court whom we met in university days, and it was reasonably foreseeable in the 1980s that some of those colleagues would reach positions of influence, or at least second-tier celebrity status. Justice Natalie Adams is one such lovable colleague, who I understand is about to hand down a reserved judgment of mine. Her Honour was and always and remains a formidable organiser. Justice Sarah McNaughton was a formidable debater in government honours class and was earmarked for a future in radical politics. For example, the leader of Extinction Rebellion. On the other hand, there was Justice Dangy. He was a flamboyant musical dilettante, but nevertheless still possessed a faint glimmer of moral seriousness. In 1986, Justice Jacqueline Gleeson and I discovered that we were ranked equal 50th at University of Sydney Law School, but with remarkable prescience. One of us was convinced that they would be eventually appointed to the High Court, and the other one actually was. However, what was not foreseeable, indeed, Your Honour, it was inconceivable, that was the 19-year-old Richard Button would be elevated to this great court 32 years later. Another controversial character, former Justice Rowan Dark, introduced me to Your Honour at a Wesley College function using one of Your Honour's many colourful nicknames. Under no circumstances will those nicknames be disclosed unless Your Honour contemplates returning as an acting justice. The 19-year-old Richard Button was an unconventional and extremely enjoyable companion with a great sense of humour, qualities he still retains, at least off the bench. He was far from a model student. He often disdained the wearing of shoes to lectures. He had a highly unorthodox mode of studying. He was and remains a die-hard fan of Iggy Pop and the Stooges and Radio Birdman. He was a supporter of various anti-imperialist causes, a sceptic of authority, and not known as a follower of the rule of law. It is rumoured that His Honour's long and abiding love of commercial law germinated as a young lawyer in the debt-collecting department of the State Bank of New South Wales. But his love of theatre trumped his love of debt collection and led him quickly to the glamour of the criminal law. The genius of Justice Button as a jurist was being able to maintain the solemnity of the court whilst embracing the theatre, the pomp and ceremony of the court. His Honour was a consummate performer. On the bench he would sometimes adopt the clipped mannerisms of a Colonel Clink. At other times he would adopt a different voice and persona, such as Judge Roger the Mad Bull Bullingham of Rumpole fame. but there were times he knew that humour had no place. He understood and empathised with the profound grief experienced by victims of crime. In the Bales list, His Honour inspired more fear than awe and earned him, perhaps unfairly, another nickname, No Bales Button. In the Northern Territory, Justice Dean Mildren was about to sentence a man who had committed numerous dishonesty offences whilst on bail. During the sentence hearing, His Honour asked the Crown, "Who was the bloody idiot who granted him bail?" It was, alas, Justice Mildren himself. Justice Button would never make such a mistake. When appearing before His Honour, it was pointless to secure the consent of the Crown to any proposed bail outcome. To appear before His Honour was reminiscent of appearing before Justice Peter Young in the Equity Division, who, if your opponent did not turn up, would say, "Now it's just you against me." On one occasion in June 2023, I was briefed to appear before Your Honour for a Mr X, charged with importing a large amount of cocaine. The afternoon before the application, I learnt that we had drawn, Your Honour. I advised my client that his prospects of success was a mathematical impossibility. However, luck was with Mr X. The following morning, Your Honour's associate sadly informed us that Your Honour had fallen unexpectedly ill. The Crown had another matter at 2 p.m. and readily agreed that the matter be adjourned. Unfortunately, after morning tea, Your Honour had recovered. And you returned to the bench full of vim and vigour and announced that you were ready to hear the matter. But Your Honour was met with a joint application for an adjournment. Perhaps being self-aware of your own reputation, Your Honour had clearly anticipated that move, for you shortly began to deliver a judgment, I should say, on a by-consent adjournment. Your Honour then published that judgment, which is on the website now, and sent that judgment by email to the parties. The judgment began ominously. This important bail application that relates to a very serious allegation of a conspiracy to import commercial quantities of prohibited drugs has been beset by logistical problems. First, my own regrettable absence this morning, and secondly, this is not said critically, of course, a favourite expression of Your Honour, the Crown Prosecutor, whom I think it is essential stay in the matter, has another obligation at 2 p.m. today, which was courteously and appropriately foreshadowed. Your Honour then grudgingly granted the adjournment, but the sting in the judgment was in its tail. But to be clear, I have done a lot of reading in the matter, and I order that if and when the matter is resuscitated, my chambers be approached to see whether I can conveniently hear it. A, I do so that my time is not wasted, and B, so that another judicial officer does not need to read and understand and synthesise a vast number of documents. Suffice to say, Your Honour, Mr X has not yet made another application up until this point. Your Honour's father, Philip Button, was a distinguished solicitor practising in the firm Robiliard and Robiliard. From Philip, you may have inherited your love of the theatrical. Philip had a collection of books of the great and not so great judges. One of those books recorded the life and times of the second Chief Justice of Western Australia, one Henry Wren Fordsley. The Chief Justice had failed in law and politics in England, but was appointed as Chief Justice due to his considerable political connections in WA. His biographer wrote as follows: "Whatever his position and wherever he occupied it, his career was, from beginning to end, disgraceful. His undistinguished career was marked by ambition, self-interest, contempt for the duties of office, and above all, by the quest of an easy life." Your Honour is the perfect antithesis of that judge. You were elevated to this court because you were one of the finest criminal barristers in the state and you had the right judicial temperament. Your entire career at the bar and on the bench has been distinguished. Over the last 11 years, Your Honour has presided over many serious criminal cases at first instance and appeal. Litigants and lawyers who appeared before Your Honour have been the beneficiaries of your impeccable impartiality. Your judgments are rigorous in their reasoning and are the product of Your Honour's analysis of the evidence and the law rather than any desire to impose your own political or cultural preferences. Your Honour has always kept above the fray. You have always demonstrated the quiet greatness of judicial independence and integrity, and for those reasons and others, you are held in very high regard by your judicial colleagues and the wider legal profession, as is evidenced by the turnout today. Your father would undoubtedly and deservedly have been very proud of you. Your loving sisters Jill, Linda and Liz, your redoubtable mother Coral, and your delightful partner Dagmar all celebrate your achievements and legacy, and your family and friends are looking forward to spending more time with you. As both your friend and representative of all barristers and solicitors who have been fortunate to have appeared before you, I am proud of your significant contributions to this court and the wider community. I speak for everyone present in this court, online and beyond, in wishing you, Honour, the best in the future.
Thank you very much, Mr. Strickland. Chief Justice, judicial colleagues, members of the profession, family, friends, all. I acknowledge the owners since time immemorial of the land upon which we meet today. Mr. Strickland, the drought has broken. I accept all of your submissions and agree with them entirely, except for the ones that poke fun at me, of course. Thanks for accepting my invitation to speak today and for doing me the honour of having one of the leading criminal silks in this country mark this occasion. You and I met when we were 17 and 19 respectively, and we have been firm friends ever since. We have never had a cross word, out of court, that is, and even in court, we never went beyond a terse exchange. Luckily, in that setting, the wiser of the two of us always had the last word. Regrettably, that ends in 20 minutes. Thanks also to everybody who is here today, in person and digitally. I appreciate it very much, since it is not only the conclusion of my judicial career, but also the conclusion of my career in the law generally. And if I may be permitted a moment of rhetorical alliteration, I send a particular judicial shout out to friends and family who may be dialed in and awake around the world at ungodly hours, for example, in Boston, the Bay Area, beautiful Seattle, Bangkok, and of course, die Bundesrepublik Deutschland. Although I have mixed feelings today, I'm looking back very happily on the past and looking forward very happily to the future. So I will try to be light-hearted and later recount a couple of allegedly funny stories from my judicial career. At my swearing in, I commanded members of the legal profession to obey the iron rule of always laughing at the jokes of the judge, no matter how feeble. Well, no one need curry favour in that way with Justice Button anymore. Even so, I ask your indulgence regarding my alleged witticisms one last time. Today is the conclusion of 12 years that were the matchless honour of my life, serving as a judge of this august court. That is an honour that I carried in my heart every hour of every day of my appointment, no matter how tired or distracted or flummoxed I was. And today is also the conclusion of 38 years of continuous work within the criminal law. And, as those who recall my swearing-in speech know, it is in fact the end of a relationship between criminal law and me that began when my late father first spoke to me about it when I was a boy of 7 or 8. A love affair that extends over 55 years is something special, certainly. And if ardour cools a little on both sides after 5 decades, even so, it is something to be celebrated, not mourned. Criminal law and I will never truly fall out of love and divorce, I believe, but the time has come for us to live apart. Separately, despite my relative youth, I must say that I am physically and mentally tired. Everyone knows that this job is demanding, very demanding. And I confess that there were a couple of years there where the little boat of my judicial career was slowly sinking under a flood of reserved civil judgments, even though I was bailing as fast as my little bucket would permit me. To extend the metaphor, at one stage I thought that I would have to apply to the Chief Judge for a judicial snorkel. I also detect in myself a slow but growing mutation from appropriate judicial punctiliousness to judicial querulousness, and indeed from perhaps slightly justified judicial exasperation to flat-out judicial crotchetiness. Those attributes, I hope, are not in my nature and cannot be blamed on the bar table, whose assistance to this court is invaluable, indeed essential. And the arrival of those unwelcome attributes of mine in these later scenes is a sign, I think, that it is time for me to depart the curial stage. Permit me to thank quite a few people, far too briefly. Let me first express my thanks to all those who have organised this significant and moving occasion for me, most of all the Chief Judge's Associate, Bernadette Haywood. I pay tribute to the two Chief Justices under whom I have served. Their timing was perfect, as follows. Tom Bathurst held a determined, unflappable, steady hand on the tiller during the crisis of the pandemic. And make no mistake, it was a crisis, especially for the criminal justice system, in which trial by jury, in my respectful opinion, the greatest of our gifts from the English legal system, was under serious threat. Just when the pandemic receded and it was time for bench and bar to return to the valuable life of collegiality and conviviality, Andrew Bell took the helm. That seemed to be a captaincy for which he had been rehearsing for decades. Each of those Chief Justices has been for me a source of wisdom, counsel, and of course intellectual leadership in the law. I extend my warm thanks to both of those leaders of this court. In similar vein, the various Chief Judges at common law under whom I have served have led the way intellectually, in esprit de corps, and as the first among equals of a team of wildly varying personalities in the common law division. In other words, as Chief Divisional Cat Herders. The other judges of the court, whether the rough and ready inhabitants of the common law division, the allegedly effete judges in equity, or those of the Olympian heights of the Court of Appeal, have been valued colleagues and many have become good friends. No one could ask for better support than I have received from the registry, the sheriffs, the court officers and court reporters, the maintenance staff, even indeed the car park attendants. The whole setup and atmosphere here has been one of people, whatever their roles, giving of their best to advance the administration of justice. As for my own personal staff, over the past 12 years I have worked closely with 15 others, and it has been a huge success and a great deal of fun, despite significant pressures and one or two ups and downs. It has also been very useful as an older person to be exposed to the new ideas of tipstaves in their early and mid-20s about social issues, music, fashion and so forth. The best part of that exposure has been confirmation that modern ideas about such things are ridiculous and that the views I formed in the 1970s and 1980s are absolutely correct. No, not really. I have come to accept that I have been wrong about such things once or twice. I would like to mention two among many of my excellent staff. The first is Sarah Bond, for some years my associate, and to whom my partner Dagmar simply referred as my public defender. Where I come from, that is high praise indeed. I also want to mention my longest-serving member of staff, Ellen Stiles. She has been my associate for just over 7 years, and her non-parole period, or perhaps continuing detention order, comes to an end in a matter of days. She has done an enormous amount of hard work. She has spent many nights in isolated country towns on circuit. All of that has been done without any complaint. We have had a lot of laughs together, some of them to keep from crying. And I think that in the course of 7 years, we perhaps had 2 or 3 harsh words for each other. Those words were in duty weeks, and as we all know, like Las Vegas, what happens in duty stays in duty. She has my heartfelt thanks for all that she has done, and I wish her every happiness in the future. That is no doubt assured now that she is upgrading from economy class with me to business class with Justice Campbell. Finally, on this aspect of colleagues, let me say a word about my replacement on this court. At her swearing-in ceremony the other day, as I listened to her literally prodigious achievements being recounted, I felt like an old steam train that was being replaced by a gleaming intercity express, one that can sit on 300 kilometres per hour between Berlin and Munich. Apart from that rueful self-reflection, it is a source of great pride and satisfaction for me that, of all of the members of the New South Wales Bar, I am replaced by the former Senior Public Defender, Justice Belinda Rigg. Now, for a few allegedly funny reflections. The first is that I am sure that all members of my family and all old friends of mine present who have got to know her over many decades are delighted to see that my dear mother, to whom I owe so much, is finally, after all of her countless misbehaviours, sitting today in the dock of a criminal courtroom. Separately, at 10 a.m. one day in the duty list, early in my judicial career, the courtroom was packed with a large number of commercial lawyers, all seeking urgent justice. I was conducting a call-over, trying to bring order to chaos. As part of that, one counsel explained that their case was about a deed. I foolishly exposed my ignorance by saying, "Just remind me again, please, what is the difference between a contract and a deed?" A dreadful hush immediately fell on the whole courtroom. It was as if the captain of a Qantas 380 had come on the public address system and said to the passengers, "Fasten your seatbelts for takeoff, please. By the way, does anybody know the difference between an altimeter and a speedometer?" Eventually, some kind soul at the bar table said, "Of course, Your Honour recalls that at law, one of them requires consideration, but the other does not." I was tempted to bark, "Quite so, but which is which?" But I thought that discretion was the better part of judicial ignorance and bit my tongue. In any event, the airplane of Duty Judge Week eventually took off that day, and despite stormy skies, the wings did not fall off, at least as far as I know. More recently, my team and I were sitting at Darlinghurst. We had reached the final point in a murder trial where the extra jurors needed to be balloted off before retirement. Anyone who has been part of that process knows that it is very stressful for a few reasons. Because Parliament, with respect, has mandated that it be done in a back-to-front way, whereby 12 people must be balloted on rather than 2 or 3 simply being balloted off, it is very easy to get mixed up. It is also stressful because a few jurors who have been committed to the trial are suddenly asked to leave fruitlessly. And finally, it was personally stressful on the day for me because in my previous trial, which had extended over 6 months, I had come within a whisker of jumbling the whole process up and completely ruining the trial. Anyone who has worked in Darlinghurst Courthouse knows that it is surely one of the most beautiful and historic buildings in the whole of Australia. But it is also a tiny bit run down and in some ways very impractical. Just as we started this difficult formal process, a torrential thunderstorm started. The roof of that particular grand courtroom seemed to be made of corrugated iron, with the result that the noise of the rain was louder than that on the tin roof of an old Northern Beaches weekender, and threatened to drown out completely our solemn ritual. The final complication was that for some reason the court officer had assigned each juror not with a readily identified number, but rather with a letter of the alphabet. So in the din, as my associate carefully read out a letter such as P, it was completely impossible for the jurors, quite some distance away in the jury box, to hear whether in truth it was P, C, D, G, T, and so forth. And of course, not having had a chance to prepare for this fiasco, none of us had brought to mind the NATO alphabet of Alpha, Bravo, Charlie, etc. This chaotic, unseemly, and for me, deeply irritating process limped on for a while. Finally, as the downpour continued, Ellen read out the letter B. Everyone in the jury box looked at her, at each other, and me quizzically, obviously unable to hear. So, motivated by a mixture of fear that the trial was going to go off its rails right at the end, exasperation with fate having dealt me such an unlucky hand, and a simple determination that the learned judge in a murder trial must be heard by the jury, I more or less yelled out from the bench, B, B, B as in bumblebee. Us 12 members of the community were exposed to the majesty of the Supreme Court of New South Wales, administering criminal justice. Finally, many have asked me what the future holds. It is unwritten, of course, but the tentative plan is the following. Some years ago, I returned to ancient Mediterranean cultures, what used to be called classical studies, through the reopened door of Latin. That has been a source of huge enjoyment and will continue. Permit me to say that the story of the slow fall of the Roman Republic, deeply flawed and oligarchical, but even so in some senses a democracy, and its replacement with an authoritarian regime, indeed a military dictatorship, is not just an exciting tale. It is a source of reflection and instruction for anyone who has lived during the 20th and 21st centuries, and indeed who is alive right now in 2024. And the closely related life story of the person whom I once heard described as the most impressive teenager in the history of the world will also be the subject of further study and contemplation by me. No, that was not the self-description in a Tipstaff application, although some have come close to that. If you would like me to tell you who that person is, I will do so at morning tea. But be careful, you may not be able to escape me in time to get to a coffee that is hot. Separately, one of the few intellectual failings to which I will admit is my inability to learn German properly before now. I have only been living with and loving a German woman for 27 years, so I think we can all agree it is probably time. I approach the task of becoming fluent in German with trepidation. After all, there are 16 forms of the definite article and 8 or 9 ways to form a plural noun. Having said that, compared to trying to figure out what the Civil Liability Act is actually getting at, or the meaning within the common form of criminal appeals of no substantial miscarriage of justice having actually occurred, I think that German is going to be a snap, don't you? As well, I intend to take the chance to learn much more deeply about the wisdom and beauty of the one absolutely authentic culture of this country. By that I mean our magnificent Indigenous culture, the only one that has not been imported from elsewhere. Finally, I am looking forward to spending much more time with my partner Dagmar. She, of course, is already very busy with golf, Italian and countless other fun activities, so that anticipation of mine may run only one way. Fulfilling this difficult role over the past 12 years would have been completely impossible without her love and support at every moment. And after years of me being away on circuit or leaving for work in the early hours and getting home long after the sun has set, I am looking forward to the two of us walking together in sunshine and laughter rather than in literal and figurative darkness. That is more than enough about my past, present and future. You are all busy, and I must let you go in a moment. Busy with trials, hearings, appeals, judgments, written submissions, conferences, preparations and completions of every kind. I am busy today as well, I must say. I have a very inviting new book to read about the Weimar Republic and an even more inviting couch on which to read it. Friends, will you all permit me, one last time in my judicial career, to commit the sin of repetition? Thank you, every one of you, for the kindness you have shown me by being here today. The court will adjourn now.
Silence all stand.